rechargeable light here too, so that you can at least see my face enough to know that it's the judge, not some wuru. Okay, thank you. Yes, this one. Please stop speaking in your dialect when you have joined Zoom now. Cancel.
My lord.
You are speaking in your dialect and you don't know that you have joined Zoom. And it's not only me and you, this thing is live.
As the accomplice.
Those that are interested are watching us.
As the accomplices.
You are for which case?
My lord, I'm for number 53, my lord.
Yes. Or you are the one that I said your place is that?
Yes, yes, my lord.
Okay, good. I can see your face now.
I'm trying to, because there's no lighting where I am.
Okay. So we will start the judgment with AK 38 2019.
As the culprits.
That is Olutayo. So let's take appearances. And you know that getting copies of the judgment is until Justin resumes strike, isn't it?
Yes,
good, thank you. Appearances, gentlemen.
Please, my lord.
Yes.
You, Ebo. With me, for the defendants, is A. Imade Bello.
A.
Imade Bello, my lord.
Emmanuel.
Imade Bello, my lord. The son of the senior police.
Spell it for me, sorry.
Okay, and the company is IMADE
I what?
IMAM as in Monday.
Okay, IMA
GB IMA, my lord, sorry, my lord. IMADE GBE FO. Thank you, my lord, for the defendants.
Yes.
We are for the defendants, my lord.
Yes, what of Victor? Show Victor.
My lord, it seems it's not online. I don't want to see his face.
Okay. So, Egbon, the case is
Hello?
Yes, the case is for what?
Judgment, my lord. Case for judgment, my lord. And we are ready for it.
Okay, the judgment is ready.
Yes, my lord.
The judgment of the court. in the National Industrial Court of Nigeria in the Akure Judicial Division holding in Akure before His Lordship Honorable Justice K.D. Damla, dated this 7th day of June 2021, suit number NICN/AK/38/2019 between Mrs. M. Olutayo David Clement and the Vice Chancellor of Federal University of Technology, Akure, the University Governing Council, Federal University of Technology, Akure, the Registrar, Federal University of Technology, Akure, the Federal University of Technology, Akure. Document. Introduction. The claimant took out a complaint against the defendants on 11 September 2019 and by a motion filed on 30 October 2019 Please, you can put off your mic. Is that understood? And by a motion filed on 30 October 2019 and granted on 5th February 2020, filed an amended complaint and statement of facts accompanied by documents required by the rules of this court. The defendants, by a motion filed on 12 November 2019 and granted on 5th February 2020, filed a memorandum of conditional appearance and a statement of defense accompanied by the documents required by the rules of this court. The defendant did not amend its statement of defense. The claimant also filed a reply to the statement of defense on 20th December 2019. The defendants filed a notice of preliminary objection on 13 February 2020, while the claimant filed a counter affidavit on 20th February 2020. The claimant seeks the following relief: a declaration that the appointment of the claimant as deputy bursar of the fourth defendant is valid, lawful, and justified, and being conducted in line with the federal character principle and process. A declaration that the claimant is entitled to payment of salaries appropriate to her position as a deputy bursar since the time of her appointment as a deputy bursar by the fourth defendant. An order of the Honorable Court directing the defendant for the immediate revalidation of the claimant's position and salary as deputy bursar. An order for the payment of the sum of 149,431 naira 97 kobo, being the claimant's outstanding salary arrears commensurate to her position of deputy bursar for the period of April 25th, 2017 to June 30th, 2018. An order setting aside the letter dated 16 September 2019 under the caption offer of appointment as deputy bursar, withdrawal of letter of appointment. An order directing the first to third defendants to reinstate the claimant to her position as deputy bursar in the bursary department of the fourth defendant. An order restraining the defendants either by themselves, their agents, assigned servants, previous and or any person acting through or for them from advertising the position of deputy bursar of the fourth defendant. An order for the payment of the sum of 5 million naira general damages for the trouble, humiliation, and psychological loss occasioned the claimant by the unjustified oppression of the defendant. Actually, what they have there is psychologically lost. That's what I wrote there. The sum of 350,000 as cost of this suit. Facts of the case. The claimant was employed, rose through the ranks to the point of chief accountant The defendant placed 2 advertisements in the dailies for appointment to the post of deputy registrar. The claimant applied, was shortlisted, interviewed, and appointed. The claimant was qualified based on the advertisement. The claimant was given a letter of appointment as deputy bursar dated 2nd May 2019 with effect from 25th April 2019 at a salary of 1,831,708 naira on Contis 14 Step 1. Since the appointment, her salary, that is in bracket, commensurate to the new appointment, as well as some other persons who were appointed at the same time, were directed to be put on hold by the Vice Chancellor, Professor I.A. Fawukwe. That is, you forgive my pronunciation of the name. That is the first defendant who investigated the appointment. The defendants continued to pay the claimant the salaries of a chief accountant, which was the post he held before the appointment, rather than the salaries of a deputy bursar. The defendant later set up 2 separate panels to investigate the appointment of the claimant. The defendant. Both panels found that the appointment of the claimant met all extant requirements. The claimant instituted this suit on 11 September 2019. The defendants later served the claimant with a letter dated 16 September 2019 and posted by courier on 27 September 2019 and received by the claimant on 29 September 2019, withdrawing her appointment as deputy bursar. Thus, the claimant amended her originating process. The defendant claims that claimant was not entitled to salaries of a deputy bursar and her appointment was withdrawn because she was not qualified for the post, going by the scheme of service, though she was qualified based on the advertisement for the job, or the advertisement violated the provisions of the scheme of service. Now, the case of the claimant, I will not read out the case of claimant again because it is basically encapturing just what I have already summarized, and the same thing goes for the case of the defendant. The little other details or differences will also be seen in the judgment. Is that understood?
Yes, my lord.
So, but I have said it out here in the judgment. All the pleadings of the claimant and the written addresses of both counsel, all the written addresses are buttressing and supporting their positions as captured in the facts of the case above. So we will keep all those ones. Then any little further details, we will find it in the judgment. Yes. So preliminary objection of the defendant. The defendants filed a preliminary objection on 13th February 2020, asking the court to strike out the suit for want of jurisdiction on the ground that the action is statute barred. The motion is supported by a 9-paragraph affidavit. Paragraphs 1 to 3 are the usual introductory deposition. Paragraph 4 is a reproduction of the statement of defense. The main depositions relevant to the objection are paragraph 5 to 7, which are hereunder reproduced. Paragraph 5. The cause of action accrued on the 28th day of March 2019, when the claimant's position as deputy bursar was not removed from hold as per the internal memo dated 28th day of March 2019, titled Payment of Salaries of Staff whose appointments have been revalidated. 6, that the suit was filed on 19th of September 2019, 3 months, that's 30 days, outside the statutory period of limitation under Section 2A of Public Officers Protection Act, which limits the period to filing suit to 3 months, the period which limits the period to filing suit. I think that should be 4, isn't it? For filing suit to 3 months. To 3 months after the event. Paragraph 7, that the suit does not disclose a reasonable cause of action against the defendant. The learned Uyogo. Okay, I thought it's my error. The learned Uyogos Egbon of counsel for the defendant submitted that jurisdiction is the pillar upon which the entire case before a court is built, that the defendants applicants are public officers within the meaning of Section 2 of the Public Officers Protection Act, that by the claimant respondent's amended statement of facts, isn't it? Statement of facts.
Yes.
Particularly paragraphs 18, 19, and 20, it is established that the cause of action in this suit arose on 28th day of March 2019, that it became known to the claimant respondent on 28th of March 2019 via the internal memorandum that you had been explained in the revalidation exercise. By the internal memorandum dated 28th March 2019. The purport of this is that the alleged exclusion of the claimant respondent in the revalidation exercise on the 28th day of March 2019 gave rise to the cause of action. Counter affidavit of the claimant. In a 6-paragraph counter affidavit deposed on 20th February 2020, the claimant through Olamide Omokinwa, a litigation secretary in the law firm of Awofade and Kayode Associates, deposed in paragraph 4 to, that is numerals 2 and numerals 5 to 7 as follows. That as at the time, that's 28th March 2019, the claimant respondent was still in active occupation of her position with the 4th respondent as deputy bursar, though on leave of absence. That even on 22nd day of August 2019, the defendant applicant at its 123rd statutory meeting still considered and reviewed the position of the claimant respondent as deputy bursar of the 4th defendant, and as at that time she was still considered as deputy bursar of the 4th defendant. The claimant respondent after the memo of 28 March 2019 still remained a deputy bursar of the 4th defendant, and the defendant's applicant still related with her as such. The claimant respondent was never issued any letter of suspension, withdrawal, or termination of appointment till the 29th September 2019. In his written address, Learned Oluwayemisi Olurotimi of counsel for the claimant submitted that whether the court has the requisite jurisdiction to adjudicate on a particular case is discernible from the statement of claim of the claimant, that is, it is the claimant's case as contained in the statement of claim that the court will look at, and not the statement of defense of the defendant. The state memo of 28 March 2019 was not addressed to the claimant respondent. She was on leave of absence then. No reason was given for the exclusion of her name from the memo. The memo did not query her qualifications, her appointment as deputy bursar, she was not suspended as deputy bursar or was in any way given any reason to suspect that her appointment as deputy bursar was going to be withdrawn. The defendant's applicant, as of the 28th of March 2019, the defendant's applicant still considered the claimant responding as the deputy bursar, and there was no cause of action as at that date as claimed by the defendant's applicant. That there are exceptions to the protection provided for the public officers and for the public offices and public officers under the Public Officer Protection Act. One of such exceptions is the case of continuance of damages or injury, i.e., where the salary, entitlements, or benefit of the claimant is not paid. The law is tried beyond question that claim for unpaid salary is a continuing action which is not affected by limitation law, cited Osun State Government versus San Lamin Nigeria Limited, citation fully supplied. Then there is the written address of the defendant, in which it is his contention that the scheme of service required 12 years post-qualification experience, but the advert prescribed 12 years qualification within the university system, and that was contrary to the scheme. And on that basis, it is his contention that the claimant did not have the requirement for the appointment, and that was the reason why she was not paid the salary for a deputy bursar, and it is the reason why her appointment was withdrawn. That is basically the submission of defense counsel. Then the learned claimant, the claimant's final written address submitted that the scheme of service is a guide, the guiding principle, and that the advertisement by the defendant should prevail over the scheme of service. And since the claimant was qualified and already appointed under the advertisement, that the appointment cannot be withdrawn at this stage. And then also, as we said, the submission that under some regulations, you was supposed to be placed on level 14, Contis 14, step 2, instead of Contis 14, step 1. So we go to preliminary court decision, preliminary objection. Considering the objection and the arguments of counsel already summarized above, it is the contention of the defendants that the cause of action arose on 28 March 2019 when the claimant's name was omitted from the list of revalidation. It's important to understand that there are two causes of action in this case. One, unpaid balance of salaries, April 2017 to June 2018. Two, withdrawal of appointment, September 2019. The first cause of action is for unpaid balance of salary, April 2017 to June 2018. This cause of action arose in June 2018, and this suit was filed on November, September 2018. However, it is a claim for work and services rendered. Whether the claimant will prove that claim is another thing, but the claim for work and labor done are not covered by the statute of limitation. Payment of salaries is an employer's duty to the employee. It is a labor right and cannot be cut off with limitation laws. The contract between the parties is a contract of employment, and the Supreme Court in National Revenue Mobilization, Allocation, and Fiscal Commission and two others versus Ajibola, Johnson, and 10 others, 2019 to Nigeria Weekly Report, part 1656, page 247 at 270 to 271, has held that the Public Officers Protection Act, that is proper, is inapplicable to contract of employment. see also a lot of cases on this issue. We have Captain Ogide and others versus Shola Jackson, citation fully supplied. Paniye and AGF, citation fully supplied. Salako and LEDR and another citation fully supplied. Judicial Service Commission versus Alaka, citation fully supplied. Alapiti versus Governor of Rivers State, citation fully supplied. Nigerian Port Authority versus Constituzione Generale, FCS, and another citation fully supplied. The second cause of action arose in September 2019 after the institution of this suit on 11 September 2019, which necessitated the amendment of the complaint on 30th October 2019 to include prayers 5, 6, and 7. It cannot be statute part. Accordingly, the claimant's cause of action is not caught by the Public Protection Act. The defendants argue that there is no reasonable cause of action. A claimant says she was appointed but not paid commensurate salary, and her appointment was later wrongfully withdrawn. The defendants did not deny this, but simply justified its action. It cannot be said that there is no reasonable cause of action, as the story agrees both parties is an unusual situation, unless the justification holds. There is indeed a reasonable cause of action which the court ought to determine. The objection fails and hereby dismissed. Another objection raised in the defendant's final written address is that the suit is incompetent for failure of claimant's counsel to date and sign the amended statement of facts. I have looked at the claimant's process in my file. I find that one Oluwayemisi Olurotimi signed the said amended statement of facts on the last page of the unpaginated work dated as 29th day of October 2019 and also affixed her legal stamp. The failure of claimant's counsel to respond to this point in his final written address is inconsequential. A party cannot be deemed to concede a point or argument on which there is in existence on the record a contrary evidence. This objection also fails and is hereby dismissed. I don't know if counsel for the claimant has joined at this stage.
Yes, my lord. I'm yes, sir.
Okay.
I'm G.I. Umar.
G.I.
Umar.
That is for who?
For the claimant, my lord. I'm holding the brief of VB Esho.
Yeah?
I'm holding the brief of VB Esho.
Okay.
Most obliged, sir.
Thank you very much.
Most obliged.
So you have listened so far, I believe.
Yes, my lord.
Okay. So we are now determining merit of the case. The facts of this case are not in dispute and have already been set out above. There are two causes of action forming the basis of the issues for determination. The two causes of action are unpaid balance of salaries and withdrawal of appointment. Accordingly, the issues for determination are whether the claimant has proved her claim for balance of unpaid salary. 2, whether the withdrawal of claimant's appointment was justified in law. These issues shall now be considered and determined accordingly. 1, whether the claimant has proved her claim for balance of unpaid salary. The pleadings relevant to this issue are as per paragraphs 11 to 16, 25, 27, and 29, and also in paragraph 12 to 17 and 30 of the witness statement on oath, summarized as follows. He was offered appointment as a deputy bursar on Counties 14, Step 41 in the bursary department of the court defendant, which offer was communicated to the claimant via the letter titled offer of appointment dated 2nd May 2017, that her appointment as a deputy bursar in the bursary department took effect from the 25th April 2017. The salary payable to her is an annual sum of 1,831,708. She was placed on grade level 14.1 instead of grade level 14.2 in line with paragraph 4.6 chapter 4 of Futa Condition of Service, and she wrote complaining about them. Upon assumption of duty, her salary commensurate to the new appointment was put on hold. That despite the new appointment, she was being paid the salaries of a chief accountant, which was the post she held before the appointment, rather than the salaries of a deputy bursar. That is, she was continued on the salary she was earning before her new appointment as deputy bursar. That the fourth defendant owes her outstanding salary arrears commensurate to her position as deputy bursar for the period of April 25, 2017 to June 30, 2018, when she applied for and was granted a leave of absence from the university. That her due outstanding salaries and entitlements from the 25th of April 2017 to 30 July 2018 is 149,431 naira 97 kobo. The balance of salary is arrived at by the claimant. This is the court talking now. The balance of salary is arrived at by the claimant calculating the variation or difference between her former salary, which she was being paid, and her supposed new salary on Count 14, Step 2. There are two problems with this claim. The first problem is the confusion caused by the pleadings in paragraphs 16, 18, and 19 of the statement of facts. While paragraph 16 says she assumed duty, paragraphs 18 and 19 suggest both her assumption of duty and salary were put on hold. The second problem is that the appointment of the claimant was stated to be on Count 14, Step 1, and a salary of 1,831,700. This is also contained in the advertisement for the job, Exhibit OD6, as well as in the offer of appointment, Exhibit OD7. However, the claimant calculated the variation or difference between her former salary, which she was being paid, and her supposed new salary on 14 Step 2. Her reason is this: I was placed on grade level 14 Step 1 instead of grade level 14 Step 2, in line with paragraph 4.6 chapter 4 of Futa Condition of Service, and I wrote complaining about them. It is to be noted that the claimant did not state what was the difference between her former salary and the salary on Count 14 Step 1 on which she was employed. She did not state how much was supposed to be her salary on Count 14 Step 2 so that the court could verify her calculation. Unfortunately, the defendants did not join issues with the claimant on the right placement of the claimant as a deputy bursar and the appropriate salary. The defendant was more concerned with denying that the claimant ever wrote any letter of complaint and that the claimant was not ab initio qualified for the appointment, so was never owed any outstanding salary. These are to be seen in paragraph 3, 4, 28, and 29 of the statement of defense. The relevant document here is paragraph 4 and 6, chapter 4 of Futa Condition of Service, Exhibit ER7. Chapter 4, paragraph 4 deals with annual increments. It has nothing to do with grade level placement upon promotion or appointment. Chapter 4, paragraph 6 deals with salary payable on upgrading a post. It provides as follows. Paragraph 6.1. If the maximum salary of the lower scale is less than the minimum of the new scale, the employee's salary shall be increased to the minimum of the new scale. 2. If the employee's salary is equivalent to a point on the new scale, he will normally move to the next higher point on the new scale. If the employee's salary is higher than the minimum of the new scale, he will normally move to the next higher point on the new scale. The implication of the above is that if the salary of the claimant as a chief accountant was higher than the salary of Contis 14 step 1, then she ought to be placed on Contis 14 step 2 so as to earn a higher salary in her new rank. However, the claimant did not aver such. It is not enough to aver that the claimant ought to have been placed on Contis 14 step 2 in accordance with paragraphs 4 and 6 chapter 4 of FUTA Condition of Service without more, as the court will not fill in the blank space. The claimant may be entitled to payment as a bursar on Contis 14 step 1 or step 2, but the claim for balance based on Contis 14 step 2 has not been proved. The court can only award to a claimant its proven claim besides consequential orders and fair orders in order to finally determine issues between the parties and avoid unnecessary litigation where the claimant is adjudged entitled to the order based on what is proven in evidence. See Section 14 of the National Industrial Code Act 2016. The court cannot speculate on the basis of the claimant's claim for placement on Contis 14 step 2 and cannot grant a relief that has not been proven. See Pastor Samuel Karimo and another versus Lagos State Government and another citation fully supplied, where the court held there is a conflict or uncertainty here as to where the land is located. It is not for me to speculate in the absence of evidence in that respect, as Nikki Toby JSC stated in Atibong and Ita 2014-117 LC LRCN 3101 at 3801 at 3830 at 3830 paragraph JJ. Could it be that the plan is in respect of Danish Nigeria Agricultural Company and the two parties in this appeal, that is Ifyong and Iwang? It is too dangerous for this court to speculate in the absence of evidence. After all, a court of law cannot speculate or conjecture. See Ogunye versus the state, Okonji versus Jokanma, Onyirimba versus state, Amos Trade Limited. Okay, ACB PLC versus Amos Trade Limited. Where a document is speculative in content, the court is entitled not to rely on it to make an award of order. See Olalomi Industries Limited versus MDIC 2002 Federal Window Report. And see also Manu Galadima and the State 2012 SBR 1553 SC, where the Supreme Court Akas JSC held. No court of law will presume or speculate on the existence of facts not pleaded before it. In Ayeni and Adeshino 2007, 7 Ayeni report patent 33, 263 at 264, the court held. It is strike law that who asserts or claim a relief must prove it by credible, admissible evidence, and judgment for and grant of such claims must be based on legal evidence of the highest probative value and weight. CAG Oyo State and Fair Lakes Hotels Limited citation fully supplied. In Sunday, a major and National Institute for Pharmaceutical Research and Development 2010 FPLR 8986 CA, the court held. What I'm trying to say is that the appellant failed to anchor his complaint upon the necessary legal framework upon which the court would grant the remedy desired. statement of claim was vague, where details of important facts were called for. This gap cannot be filled by the court. This is so since a court of law is not within authority to dish out remedies in vacuum. This is aptly applicable to the claimant's claim for balance of salaries on Frontis 14 Step 2. This claim for 149,341.97 being balance of salaries on Frontis 14 Step 2 fails for want of proof and is dismissed. Whether the withdrawal, issue 2 now is whether the withdrawal of claimant's appointment was justified in law. The defendant's counsel has contended that the claimant in this suit failed to establish the fact that the second defendant, that's the University Governing Council, at any time approved the publication for the post of the deputy bursar of the second defendant, or at any time approved the appointment of the claimant as deputy bursar. The approval of the publication and appointment was not put in issue by the statement of defense, as it was not raised. This issue was raised in cross-examination by Lanet Egbon Esquire, in response to which CW2 said, the approval is in the University Council's record. The burden therefore shifts to the defendant to disprove same, and this could only be done if it was made an issue, particularly by the statement of defense. The purpose of cross-examination was stated in Chief Chukwu Debere Okole Eze Amuranama and others versus Professor Peter Ebigo and others, 2016 LPLR 40456CA per OJCA as follows. The purpose of a cross-examination is to discredit a witness and demolish the case of the opposing party. It is also intended to project the case of the party conducting the cross-examination. See the case of Omishore and Aregbeshola, 2015, FAR 24803 SC. See also Oladipo Ojubayo and the State, citations supplied, and Hyson Uzewata and other versus Reverend Dr. Mike Uzewata, citations supplied. The question now is, by this question and answer, which part of the CW2 witness statement did the defendant's counsel seek to contradict? How did counsel intend to discredit the credibility of CW2 by this question? Which part of the claimant's case did counsel seek to demolish? Which part of the defendant's case did the counsel seek to project or prove? What were his pleadings in respect thereof? A counsel should always ask himself these questions before asking any question in cross-examination. A piece of evidence obtained in cross-examination cannot be contradicted in a final written address, but by contradictory evidence. Learned counsel knew that no issue was joined on approval in the pleading, and he had no means of contradicting any given answer, as the statement of defense has no contrary story in relation to approval. But he unadvisedly asked such a question only to put himself on the fighting end in the final written address. The counsel cannot argue against a fact he elicited through cross-examination without his own witness producing a contrary evidence. The issue of approval is one to be assumed in favor of the claimant by the facts of this case, and so the answer given under cross-examination is in accord with the claimant's case, and the claimant has no duty to prove what CW2 has answered defendant's counsel under cross-examination. The defendants are bound by the answer their counsel elicited under cross-examination. In this case, see Godwin Nwafo Maduka and others versus Victor Echezona Ayad Diego, where the court held the law is right that in the conduct of proceedings hearing in a matter Evidence adduced through answers elicited or obtained from a witness while being cross-examined is admissible, potent, and as good as the evidence proffered under examination in chief. Indeed, cross-examination forms a crucial and indispensable aspect of the adjudication process. Thus, evidence extracted during cross-examination has similar potency and weight in relation to the facts in contention. Consequently, where answers to questions posed under cross-examination are relevant and linked to the fact in issue, such answers cannot be swept aside with a wave of the hand, glossed over, or simply because it was procured through or under the intense heat of cross-examination and not otherwise. In the circumstance of this case, it is the claimant that has the right to object to the defender relying on any answer elicited through cross-examination but not covered by pleading. The court can only disbelieve CW2 if his answer does not accord with the claimant's pleadings and logic, or is not ordinarily believable given the ordinary course of human activity, behavior, or events. In any event, the presumption of regularity, including any needed approval, is in favor of the claimant. The claimant was not expected to investigate and establish evidence of approval before applying for the post or accepting the appointment. More so, the existence of the adverb is enough proof of approval in favor of the claimant until denied, and the contrary proven by the defendant. As for the approval of the appointment letter, Exhibit OD7, and the certificate of compliance from the Federal Character Commission, Exhibit OD12, as sufficient evidence of such approval.
God, please.
Unlawfulness of the withdrawal of claimant's appointment. The facts and the grounds for withdrawal are already set out above. In the determination of this issue, the instruments for consideration are: 1, the advertisement for the job; 2, Section 3 of the reviewed scheme of service of the defendant; and 3, the defendant's regulation. The contents of the 2 advertisements and the reviewed scheme of service, as pleaded and relied upon by both parties, are as follows. 1, Punch and Leadership newspaper of 21st July 2016. This is what it says: a good first degree, at least second-class lower division, from a recognized university in accounting, plus professional accounting qualifications, in bracket ACA, ACCA, ACMA, CPA, ANAN, with a minimum of 12 years university working experience, out of which at least 5 years must be as chief accountant or chief auditor. Applicants must be computer literate, have substantial knowledge of the relevant accounting packages. Possession of higher degree will be an added advantage. Then Punch and Leadership newspaper of 25th July 2016. Similarly, applicants for the post of deputy registrar, deputy bursar, deputy director of audit, and deputy director of courts must have 12 years working experience in the university system and must have spent at least 5 years as principal, assistant registrar, chief accountant or chief auditor, chief internal auditor or chief accountant, and chief coach respectively in the university system. Now, Section 3.0 of the review scheme of service provides for any candidate to be considered for the post of deputy bursar, he or she must possess a good first degree in accountancy, plus a professionally recognized accountancy qualification, plus ICANN, ACA, ACCA, ACMA, plus 12 years post-qualification experience. Now, the defendant did not deny, but rather admit that the claimant met all the requirements for the appointment per the advert. This is what DW, besides the defendant's pleadings, admitted under cross-examination, and I quote, "It is the management that determines what goes into the advertisement. It cannot use requirements not advertised for appointment. I am aware that two different panels reviewed the appointment of the claimant and both came to the conclusion that the appointment of the claimant met all extant requirements. The claimant met all the requirements in the advert as per my paragraph 3. The claimant did not contribute to the placement of the advert." The defendant's defense is this. I quote again, that upon critical review, it became obvious that the addendum publication of 25th day of July 2016, upon which the claimant was appointed as deputy boss of the fourth defendant, violates the reviewed scheme of service of employees on Contis OCs and above administrative and professional staff in brackets for the accountant cadre of the fourth defendant, that the appointment of the claimant as deputy bursar of the fourth defendant was irregular and not made pursuant to the reviewed scheme of service of employees on Contis OCs and above, in bracket now, administrative and professional staff. Now, first, it is to be noted that the defense cites the requirement of a minimum of 12 years university working experience in the addendum publication of 25th day of July 2016 as the one that violates the scheme of service, thus the disqualification of the claimant after appointment. Now, there were two adverts, one on 21st July 2016 and the addendum publication of 25th July 2016. The implication is that by the defendant's reckoning, the advert of 21st July did not violate the scheme of service. What I find in the main advert of 21st July is also a minimum of 12 years university working experience. How the same provision of a minimum of 12 years university working experience in the 25th July addendum contravenes the scheme of service when the same provision in the initial advert of 21st July does not violate the scheme of service is still in the mind of the defendant and is undisclosed. This line of argument does not hold water. The only remaining question now is whether, in view of the contents of the advert, the claimant meeting the requirements, and two panels of the defendant reviewing and finding that the claimant met all the requirements for the appointment, Federal Character Commission issuing a clearance certificate for the defendant can withdraw the appointment of the claimant on the basis of the addendum publication of 25th day of July 2016 being contrary for being contrary to section 3.0 of the reviewed scheme of service. The bone of contention here is that while the scheme of service requires 12 years post-qualification experience, the advertisement for the job placed by the management of the university required 12 years working experience within the university system. The claimant met all the requirements in the advert except that in the scheme of service, which was not the basis for the application, shortlisting, interview, and appointment. The claimant was an accountant at class since 19.
Okay.
Sorry, I have to put it in the correct paragraph. The claimant was an accountant, third class since 1990. The claimant obtained a second class upper degree in accounting 2013 and ACA in 2010. The claimant has 20 years working experience within the university system, that is from 1997 to 2017. She has gathered experience in the university system as accountant 2, accountant 1, senior accountant, principal accountant, and chief accountant. By the scheme of service, the next rank is deputy bursar, which is by appointment. These are all the requirements in the advertisement, and it deviates from the scheme of service only in terms of 12 years working experience within the university system in the advertisement as opposed to 12 years post-qualification experience in the scheme of service. The claimant was found appointable by the interview panel. He was found suitable for appointment as confirmed by the panels of investigation set up by the first defendant, Exhibit OD 14. Exhibit OD 18 is the procedure for recruitment into the federal service by the Federal Character Commission. Paragraph 4 says that under no circumstantial and unqualified candidate be shortlisted purportedly on the basis of federal character consideration. It is in evidence that the Federal Character Commission was present at the interview exercise of the claimant and others. The commission thereafter issued a certificate of compliance to the fourth defendant addressed to the first defendant on 17th May 2017 for the appointment of 17 officers, of which the claimant is number 16 on the list. You see that in Exhibit OD 12. The implication here also is that the Federal Character Commission adjudged that no unqualified candidate was shortlisted for interview for the job and that all the candidates were qualified for the job. It is clear that the claimant was apparently qualified for appointment into the position of deputy bursar. The alleged violation of the scheme of service by replacing 12 years post-qualification experience with 12 years working experience within the university system by the fourth defendant itself is inconsequential in the circumstance. It has not done any violence to the scheme of service. It does not affect the fact that the claimant is qualified for the position. I agree with the claimant's counsel submission that the scheme of service is a reasonable guide and not an iron cast rule of law, like the Constitution or an act that requires legislative amendment before the council can make the slightest variation therefrom, as the council has done in this case. See paragraph 7 on page 2 of that page, II, numeral 2 of the scheme of service, Exhibit EOD 20, which provides as follows, and I quote what the scheme of service says. The document will serve as a source of enlightenment to staff and a guide to management for appropriate decisions. More so, this is appointment, not promotion. The requirements advertised and used by the counsel of the fourth defendant supersede the requirements in the scheme of service. CSA versus Okechukwu, 1998, 5 Nigerian Law Report, part 548, 43, at pages 85 to 86, where the Court of Appeal held, where a condition precedent the doing of any act is laid down by the Constitution or statute, such condition cannot be waived, but must be strictly complied with. Any non-compliance vitiates the entire procedure. The next line I underline the next statement. But where the requirement is laid down in the rules of court or other subsidiary legislation, then such provisions could be waived, compromised, or varied. Adego Chemicals Limited versus Adesanya, citation supplied, Hill Station Hotel Limited versus Adeyi, citation supplied, Olagbegi and Ogunoye, the second, citation supplied, Tayo Oyetibo and Covers had been approved, citation supplied. Underlining supplied for emphasis. In any event, if at all the variation, which I find has done no violence to the scheme of service or any legislation, was wrong, then the fault is not that of the claimant or the defendant. The university cannot make a deviation from the scheme, appoint the claimant based on his advertisement, and later withdraw the appointment on the basis of compliance on its part with the scheme of service. That will amount to the defendant setting up the claimant or any other person so appointed, since the job was advertised for the general public, for oppression, humiliation, public ridicule, psychological trauma, and depression, and where a person has resigned his former job to take up the appointment, loss of source of livelihood. The finality of the decision-making power of the second defendant was consummated when it issued to the claimant a letter of appointment as a deputy bursar. The subsequent attempt to review the appointment of the claimant after issuance of appointment letter actually tampers with the finality of the decision of the second defendant. The statement of law on this point is right. The law forbids a person benefiting from his own wrong. A man cannot be allowed to take advantage of his own wrong. The law will not allow a man to take benefit from an act or omission of his own making. In other words, a man cannot take advantage or reap benefit from his own wrong. The court never allows a party to benefit from a wrong albeit traceable to the party. See Inyang versus Ebong, citation supplied. Adedeji versus NBN Limited, citation fully supplied. See also Alexander Babatunde Fakayode and Adeniran Adeniyi and another, citation fully supplied. And Ernest Ejigini versus Godwin Ezenwa and other, citation fully supplied. Summary. In view of the above, the findings and holdings of the court are summarized as follows. The claimant has not proven that she ought to have been placed on Contis 14 step 2 instead of Contis 14 step 1. The claimant has failed to prove that the defendant owe her the sum of 149,421 as salary balance from 25th April 2017 to 30th June 2019. The claimant is entitled to her salaries commensurate to her position as a deputy registrar as a deputy bursar. The claimant is entitled to payment of her salary commensurate to her position as deputy bursar from 25th April 2017 to 30th April 2018. The claimant was qualified for appointment into the post of deputy bursar of the fourth defendant. I think it's deputy bursar.
Yes, my lord.
The defendants cannot withdraw the claimant's appointment on the basis that she was appointed based on the university advertisement requiring 12 years working experience in the university system rather than 12 post-experience qualification as stated in the defendant's scheme of service. 5. The requirements advertised and used by the counsel of the fourth defendant supersede the requirements in the scheme of service. Okay, that's 6. 7. The appointment of the claimant on the basis of 12 years working experience in the university system rather than 12 years post-qualification experience, if at all was wrong, it was the defendant's wrong, not the claimant. The defendants cannot benefit from their own wrong. And 9, the withdrawal of the claimant's appointment as deputy bursar is unlawful, null, and void. Court order. For the avoidance of doubt, it is hereby declared and ordered as follows. 1. It is hereby declared that the claimant has not proven that she ought to have been placed on Confis 14 Step 2 instead of Confis 14 Step 1. It is hereby declared that the claimant has failed to prove that the defendants owe her the sum of 431 a salary balance from 25th, 20 April to 30th June 2018. It is hereby declared that the claimant was entitled to salary commensurate to her position as deputy bursar from 25th April to 2017 to 30th June 2018. It is hereby declared that the appointment of the claimant as deputy bursar of the fourth defendant is valid. Hereby declared that the withdrawal of the claimant's appointment as deputy registrar as deputy bursar is hereby declared unlawful, null, and void, and hereby set aside.
Copy.
The claimant is hereby restored to her post as deputy bursar of the fourth defendant. The defendants are hereby ordered to pay the claimant's salary commensurate to her level as deputy bursar from the date of her appointment as required by the scheme of service. Cost of 400,000 naira is hereby awarded in favor of the claimant. This is the judgment of the court and it is entered accordingly.
Please.
So this judgment is ready, but how you get a copy depends on how you liaise with the registry, which I imagine should be after the call of Jason strike.
I copy.
One other thing is this. As soon as possible, after the delivery of the judgment, I will send it to our ICT center at the headquarters. And they too will, as soon as possible, put it up on our judgment portal. So even before you come to court to get a copy, you can access it on the judgment portal. It would have been given to the world, even before you see a physical copy. Yes, let me hear Omar.
My Lord, we are very grateful for the well-researched judgment. And we pray for more wisdom for my Lord and good health. We are most grateful, my Lord.
Yes.
Yes, my Lord. On our part, my Lord, we equally thank my Lord for a well-delivered judgment and for the industry put in it, my Lord. We are grateful.
You are welcome.
Thank you, my Lord.
Thank you, my Lord.
All right, that is it for this one. The next one is only half of what we have done, or less than half. So we will not take much time.
Want to listen to the audio.
All the corrections. Don't jam, right? AG Kwara State. IL 53 2020. Appearances. Put on your mic. Olushola, put on your mic. Your mic is off.
As a copies. With profound respect to my Lord,
yes.
My name is Olushola Edare. I most humbly appear for the claimant.
Yes, who is for the defendant?
Yeah, with utmost respect, my Lord. I am
Yes.
Malik Abdulmajid. Only the proof of SR Ashaolu for all the defendants, sir.
I thought you have been appearing in this matter.
No, sir, my Lord.
Okay.
Only the proof of SR Ashaolu. SR Ashaolu for all the defendants, sir.
Okay. Yes, Dare.
Yes, my Lord. The matter is for judgment today.
Yes.
And subject we believe is ready. If it's ready, my Lord, we are ready for the judgment.
Yes. Malik.
Yes, my Lord. We are fully ready, sir, my Lord.
I just discovered I am sweating. Meanwhile, I have light and AC in.
As the corpus.
I was wondering, I thought, is that there is no light or what? Why am I sweating? All right.
Okay.
The judgment is ready.
As the corpus.
Now, this is the judgment of the court. I earlier informed you people that you may be able to get a copy only when Houston calls of their strike.
As corpus.
Yes, but my own is ready. I will upload it to our judgment portal today for the world to see what you are going to obtain when Houston strike. You too, you can see. Yeah, you hear it now, you see it there. In the National Industrial Code of Nigeria, the Forestry Division was in Akure before its launch was justified. Dated the 7th day of June 2021, suit number NICN/IL/53/2020 between Attorney General of Kwara State, claimant, and Nigeria Labour Congress, Trade Union Congress, Joint Negotiation Committee, Aliu Isa Ore, Ezekiel Adegoke, Saliu Suleiman, defendant. The claimant took out an originating summons on 8 October 2020. The claimant seeks for the determination of 4 questions and the grant of several reliefs as follows. 1. Whether the proposed strike action set to be commenced in the communique dated 28 September 2020 and affirmed in the communique dated 8th day of October 2020 issued by the defendants is in compliance with the relevant statutes and International Labour Organization ILO requirements for declaring a strike action, as well as the decision of this Honorable Court in suit number NICN/ABJ/197/2016 between Federal Republic of Nigeria and another versus Nigeria Labour Congress and another. 2. Whether the proposed strike action originally slated for Monday, 12 October 2020 and now rescheduled for Tuesday, 13 October 2020 or any other date as threatened by the defendants is in compliance with Section 18(1) and 42(1)(a) of the Trade Dispute Act, Capti LFN 2010 and Section 31(6)(a), B, C, and D, Trade Union Act, Cap T14 LFN 2020. 3. Whether having regard to Section 7162, 6, 7, and 8 of the Nigerian Constitution, which guarantees independence of the local government in terms of existence and income, the governor of Kwara State can be compelled or coerced to sign minimum wage for employees of local government councils in Kwara State, whether by the provisions of Section 14(2) of the Nigerian Constitution as amended, the claimant representing Kwara State government is not under a constitutional obligation to prevent the loss of lives and properties that will occur as a result of the defendant's proposed strike action, originally scheduled for 12 October and now rescheduled for 13 October 2020, whereof the claimant seeks the following declarations and orders. The declaration that the proposed threatened strike is not in compliance with relevant statutes and the International Labour Organization ILO requirements for declaring a strike action, as well as the extant judgment of this court in suit number NICN/ABG/179/2016. A declaration that the proposed strike action is in violation of Section 18(1) and 42(1)(a) of the Trade Dispute Act, Capti 11 2010, and Section 31(6)(a), B, C, and D of the Trade Union Act, Capti 14 11 2010. A declaration that having regard to Section 7 and 16267 and 8 of the 1999 Constitution, which guarantees independence of local government in terms of existence and finance, the governor of Kwara State cannot be compelled or coerced to sign minimum wage for employees of local government councils in Kwara State. A declaration that by the provisions of Section 14(2) of the Constitution as amended, the claimants are under a constitutional obligation to prevent the loss of lives and properties that may occur as a result of the defendant's proposed strike action. 5. A declaration that the proposed strike action is not justified in view of its adverse economic effects on the prosperity of Kwara State. 6. An order declaring the proposed strike action by the defendants as unlawful, illegal, null, and void. An order of injunction restraining the defendants, their affiliates, or any other body or person acting through them or as their agents or privies from engaging in any strike action on the issue of minimum wage or any other reason whatsoever, originally scheduled to commence on the 12th October 2020 and rescheduled for 13th October 2020 or any other date. By a motion or notice for extension of time filed on 13th January 2020, the defendants sought and obtained leave to file their counter affidavit, which was granted on 18th February 2021. The defendants filed a 27-paragraph counter affidavit, and the claimant filed a further affidavit on 2nd March 2021. Case of the claimant is that negotiations have been concluded with the defendants with regard to the new minimum wage. That's in a 48-paragraph affidavit in support of the originating summons. proposed by Tolulope Onyekosi, said that the negotiations have been concluded with defendants with regards to 30,000 naira minimum wage for Kwara state workers. That Kwara state government, after the conclusion of the negotiation for the new minimum wage with the defendants, the claimants agreed and assured the defendants of the claimants' readiness to pay the minimum wage. That in implementing the said minimum wage by the claimant as agreed, the claimant commenced the verification and auditing of the workers in the civil service. The negotiation with the defendant does not cover the wages of local government workers. Thereafter, I think local government should be capital L and capital G, isn't it?
As the corporates.
As corporates, sir.
Local government workers. Thereafter, the defendants issued a press release on the 7th day of October 2020, rejecting the auditing verification exercise and placing of their members on standby for an indefinite strike action, which will commence on 12th or 13th day of October 2020. The defendants issued a communique on 28th day of September 2020, making 5 demands from the claimant and fixing the commencement of a strike for Monday 12, 2020, Exhibit A. The defendants gave the claimants 14-day ultimatum effective from 28 September 2012 October or to 12 October 2020, threatening to embark on strike action if the defendants' demands are not met. That the decision of the defendants to commence industrial action or strike was later affirmed in another communique issued on the 8th day of October 2020, and the strike was scheduled to commence on Tuesday, the 13th day of October 2020, Exhibit A1. Issues as stated in the said letter dated 28th of September 2020 were never discussed in the negotiation. But after negotiations between the parties, the respondents sought to review upward the negotiated minimum wage for Kwara state workers by 50%, which is impracticable in view of the resources of the state. The claimant has not withheld deduction of take-off dues of the defendant. The health workers in the state have been paid allowances in view of the health risks they have endured due to the COVID-19 pandemic. That the Kwara state government is not in a position to implement the approved 10% outstanding conhests to local government workers in view of the NFIU guidelines. That is, NFIU is National Financial Intelligence Unit guideline, which restrains state governments from exercising any control over funds meant for the local government within its state. That the claimants will only be responsible for the minimum wage of the members of staff of the Kwara state government and not staff of the local government council. That the planned strike will involve essential services, including health workers, which will exacerbate the looming COVID-19 pandemic in the state. That with the guidelines of the National Financial Intelligence Unit, NFIU, and other policies on the financial autonomy, local governments now receive their allocation directly from the federal government. That the claimants cannot be held responsible for the minimum wage of the staff of the local government councils in Kwara State, and the governor of Kwara State is always ready to sign the agreed minimum wage for all other workers in the establishment of the state other than local government employees. Written address of Claimant Council. The Claimant Council argued questions 1 and 2 together, questions 3 and 4 together. And his arguments are just in line with what is in the depositions. And he urged the court to grant the reliefs prayed for. Why I'm not reading the submissions is that it is just an amplification of what is proposed. We understand?
As corporation.
Case of the defendant. The fourth defendant deposed to a 27 paragraph counter affidavit on behalf of And according to him, that the verification exercise have since been completed in February 2020, that parties have agreed on what government can pay. It only remains for governor to sign the collective agreement that was left out, that when negotiation was on, it comprises of local government workers, that till date, both the state and local governments still maintain joint account, otherwise known as JSC, which is headed by National Union Local Government Employees are members, that a total autonomous that a total autonomous, I put it thick, should be total autonomy, will vindicate or justify the stance of the claimant that the state will not pay the local government workers 30,000 minimum wage. The averments in paragraph 27 are false, that the strike had already begun before the services of the court processes and non allegation repeated. It was a peaceful demonstration, that averments in paragraph 28 are clear payment of minimum wage to all categories of workers in the state. That is exactly what the parties agreed on. Let it come to fruition. It was the delay that brought about 50% upward review in view of the economic situation in the country. Parties have since settled since February 2020, only for the governor to sign a collective agreement, only to take out this originating summon again to further delay the joint agreement. In his written address, learned counsel for the defendants made submissions also in line with the affidavit, which I will not repeat them here.
As copies, sir.
For the affidavit, the claimant filed a further affidavit in which he denied this, basically that the local government workers were not involved. And then he repeated his arguments about the requirements of Trade Dispute Act, Labor Act, International Labor Organizations, and the suit number NICNABG 179. He is saying that they are not saying the defendants do not have a right to that it is not the claimant's case that defendants do not have right to strike action, but that there are preconditions which ought to be fulfilled as laid down by law, which the defendants have not met, and that the local government employees were not contemplated during the negotiation the claimant had with the defendant. Claimant cannot be held liable for the payment of 30,000 naira minimum wages for local government workers. Court decision. The defendant raised a preliminary issue that the instance does not fall into categories of cases to be heard on an originating summons, considering the position of the claimant as established by her affidavit evidence, and that the defendant's affidavit evidence, and that of the defendant's affidavit evidence. Counsel urged the court to look at the affidavit and the exhibits attached, that there is an air of friction which renders this suit not fit for this procedure. Counsel did not point out specific conflicting facts or friction, but left it for the court to fish out. I take that again. Counsel did not point out specific conflicting facts or friction, but left it for the court to fish out. This is not proper. Counsel should point out such conflicts or frictions as he shall be bound to point it out on appeal in the event of a ruling in favor of the claimant and an appeal on this issue. It must first be noted that the affidavit and counter affidavit seem to establish a conflict different from what appears. I take it again. It must be noted that the affidavit and counter affidavit seem to establish a conflict. That is a case. Conflict in this term now, a case. Different from what appears from the questions for determination and their reliefs. It must first be noted that the affidavit and counter affidavit seem to establish a conflict different from what appears from the questions for determination and their reliefs. Similarly, the documents attached seem to establish a case different from, let me not use conflict here, let me just use the word case. It must first be noted that the affidavit and counter affidavit seem to establish a case different from what appears from the questions for determination and their reliefs. Similarly, the documents attached seem to establish a case different from the questions for determination. The questions for determination relate to whether the governor can be forced to sign minimum wage for local government workers. The affidavit and counter affidavit disclose that the conflict is as a result of the failure of the governor to sign the negotiated minimum wage agreement. The claimant justified it on the need to carry out a staff audit and verification exercise, which the defendants have rejected. But the defendants claim that the verification exercise have been completed. However, justice is better done from the angle of what parties perceive to be their conflict. An originating summons is a procedure that avoids waste of time, but it is only suitable where the facts necessary for determination of the issues are either not in conflict or can be resolved from the documents attached. The procedure does not admit of where the facts relevant to the determination of the question in issue are conflicting and cannot be conveniently resolved from the attached exhibit. Apparently, there are conflicts between the questions for determination, the deposed affidavits, and the attached documents. But a suit should not be dismissed for want of proof or inconsistency under an originating summons, while it is possible to call for such proof and better pleading. See Pamfa Oil Limited versus AG Federation 2013-18 weekly report, part 852, page 453, and then also 2003-910 SC, where the Apex Court Pabego JSC held. The very nature of an originating summons is to make things simpler for hearing. It is available to any person claiming interest under a deed, will, or other written instrument whereby he will apply by originating summons for the determination of any question of construction arising under the instrument for declaration of his interest. And that is found in Order 38 Rule 1 and Order 48 Rule 11 of the rules that was under consideration. It is a procedure where the evidence in the main is by way of document, and there is no serious dispute as to their existence in the dealings of the parties to the suit. In such a situation, there is no serious dispute as to facts, but what the plaintiff is claiming is the declaration of rights. If there are serious disputes as to facts, then a normal writ must be taken out and not originating summons. There they relied on Doherty and Doherty 1968 NMLRS Nigeria Model Report, page 241. They say see also I know Amir Oloyede and Laura Omoni Oluyede, 2014, LPLR 24384CF. I have read the affidavit, counter affidavit, and submissions of counsel. And considered the attached exhibit. There is a conflict. Okay, I take it again. I have read the affidavit, counter affidavit, and submissions of counsel and considered the attached exhibit. There is a conflict as to whether or not the local government workers were part of the negotiated minimum wage agreement yet to be signed by the governor of Kwara State. There is also conflict as to whether or not the verification exercise has since been completed, or it is that the defendants rejected the verification exercise. The conflict as to whether or not the local government workers were part of the negotiated minimum wage agreement cannot be resolved on the basis of the present affidavit and counter affidavit in the absence of the said agreement. There is also conflict as to whether or not the verification exercise has since been completed, or is it that the defendants rejected the verification exercise. Evidence is needed to establish this affirmation. On the whole, if the fiction succeeds, the matter is hereby transferred to the general court list for hearing of evidence. Parties are to file an exchange pleading. The claimant should file his statement of facts within 2 weeks of this ruling. And if Juson is still on strike, And if Juson is still on strike 2 weeks after this ruling, then immediately Juson resumes work and the defendants within 2 weeks upon service.
As the court
This is
proceeds.
the judgment of the court and it is entered accordingly.
As the court proceeds. Point of line, my lord.
Yes, who is talking?
My lord, Olusola Dare first. We commend my lord for the well-considered decision. I must say what we have learned from my lord. And we are indeed grateful to your lordship. We shall file the processes as directed by my lord. Thank you, my lord.
Thank you very much.
Yes.
Please,
Yes, my lord, we appreciate the industry, sir.
Okay, this is Malik.
Malik Abdul, sir.
Yes.
We appreciate the court, sir, for the ruling just delivered. And I will pray that Nematala continue to bless the court, sir.
Okay. Dare.
Yes, my lord.
Please read the judgment and listen to the judge.
As the
Before
court
you
proceeds.
find, I said read the judgment. And
Yes,
as
my
you
lord.
read my judgment, listen to the judge before
Yes, my
you
lord.
file your next processes, please.
As the court proceeds.
Yes, when you listen to me, then you read what you have filed before. Then you will see, you will probably see what I'm talking about. Forget about, except if you want to go on appeal. Eh?
As
If
the
you
court
want to go on
proceeds.
appeal, it's a different case. But you don't want to go on appeal, then forget about whether you think I am right or not. Just
As the court
get
proceeds.
to understand what problem I have with your process. It will guide
As the
you
court
in
proceeds. As the court proceeds.
Thank you very much.
I'm grateful to my lord.
Thank
Yeah,
you. Thank you. You are welcome.
Thank you, my lord.
Well, that is the end of today's proceedings, and you are welcome. I hope you people are on our platform, NICN Judgment platform portal.
I'm not there yet, my lord.
Okay, try to be there so that whether today or tomorrow, you should be able to read your judgment on the official NIC platform, judgment portal, even
As a
before you
copy.
get a hard.
As a copy, please.
So that from there you can, if possible, I don't know whether it can be downloaded. I don't know. I really don't know whether you can download from there, but you can read it from there. I know that one. Okay, thank you, gentlemen. And that is.
Yes, sir. Thank you, sir.
Yes.
Yes, sir. I am already on the platform, sir.
You say?
I'm already on the platform, NICN platform.
Not that's the judgment portal. I'm talking about our judgment portal.
Okay, sir. Maybe I will go there when I'm done with
that
this
one that has NICN with the sign of the gravel. Is it that one?
Yes, sir.
The app.
Yes, sir.
That's what I'm talking about.
Yes, sir.
So
Thank you, sir.
You can ask with your colleague to download the app.
As a copy, please.
Darren, you can call him, liaise with him. He will direct you on how to get the app as well. Yes.
As a copy, please.
Thank you very much.
Thank you, my lord.
Yeah,
Okay.
Thank you, sir. I'm very grateful,
Okay.
sir.
Okay. Fatai. Because I don't know, I don't know whether I'm actually the host of this meeting or is it Fatai. It seems to me it's Fatai. So he should be the one to end the meeting. Fatai.
Yes, my lord.
Is that, can you end the meeting? Can you end the meeting? Hello? Okay, councils, you can leave so that I will just leave.
Thank you, my lord.
You can leave, just
yes,
leave.
My lord.
Yes.
As a couple.
If I can't get them to end the meeting, I also leave, that's all.
Let's end
Abuja, NICN, NICN, can you end the meeting?